Jasmine Crockett stepped into the Supreme Court expecting tough questions. But no one expected her argument to hit so hard that Chief Justice John Roberts stopped the entire courtroom mid-hearing, broke tradition on live record, and publicly acknowledged her reasoning, creating a rare power shift that left justices, lawyers, and the nation watching in stunned silence. The courtroom was already full long before Jasmine Crockett stepped up to the podium. Lawyers sat rigid in their seats. Clerks lined the side benches with notepads, ready. Reporters packed the press row. When Crockett finally rose, the room did something rare. It quieted itself. She placed her hands on the wood and looked straight at the bench, not timid, not rushed, but locked in. "Let's be honest," she began, her voice steady but sharp. "This court is about to decide whether zip codes still get to write children's futures." A few heads snapped up. She didn't ease into her argument. She went straight for the nerve. "We pretend this is about budgets and local control, but what we're really doing is allowing poverty to masquerade as policy." Across the bench, a conservative justice shifted in his chair. Crockett didn't flinch. "If equal protection only applies when it's convenient, then it's not protection at all, it's permission." The room tightened. Even the clerks stopped whispering. Crockett could feel Chief Justice Roberts watching her closely, measuring every word. She knew he almost never disrupted proceedings, and that knowledge only pushed her further. "Today," she said, "you don't get to hide behind polite language. You're being asked to confront what this system has been quietly tolerating for decades." Then she went where most advocates refuse to go. She named the precedent everyone tiptoes around. "This court once told families that education is not a fundamental right," she said, letting the words hang. "And that decision has been used as a shield to excuse neglect ever since." The air shifted instantly. Crockett leaned slightly forward, eyes locked on the bench. "But let's stop pretending that ruling gave states permission to starve classrooms and call it federalism." A few attorneys in the gallery exchanged uneasy glances. Crockett pressed harder. "You built this legal framework. You set the standards. You defined equal protection. And now, when those standards expose uncomfortable truths, suddenly everyone wants to step back?" Her tone sharpened. "That's not restraint. That's avoidance." The silence that followed wasn't calm. It was electric. Crockett paused just long enough to let the weight settle, then added quietly, "I'm not here to make this easy. I'm here to make it honest." The room went completely still again. Not the quiet of boredom, the quiet of tension, the kind where everyone is waiting to see who moves next. Crockett paused just long enough for the weight of that moment to settle, then continued, steady and controlled. Justice Kagan leaned forward and broke the tension with a question that hit like a warning shot. "Counselor," she said, "if we accept your framework, what stops this court from being flooded with lawsuits over every locally funded service?" The room stiffened. Everyone understood the subtext. Open this door, and chaos follows. Crockett didn't hesitate. She lifted her chin slightly and answered with controlled force. "What stops it," she said, "is the Constitution itself." A few justices exchanged quick glances. One clerk in the front row uncapped a marker and began writing aggressively, underlining phrases as Crockett spoke. "Education isn't just another public service," Crockett continued. "It's the entry key to every other right this court claims to protect. Voting means nothing if you can't read the ballot. Free speech means nothing if you were never given the tools to understand it. Jury service means nothing if you were never taught how the system works." Her tone sharpened. "So let's stop pretending this is about slippery slopes. This is about whether this court is willing to defend the foundation it already stands on." Then she laid down her framework, slow and deliberate, making sure every word landed. "First," she said, "there must be proof of extreme and persistent funding gaps. Not temporary budget dips, not political noise, but structural inequality that lasts for years." The clerk's pen moved faster. "Second, there must be clear evidence that those gaps directly damage educational opportunity, Lower graduation rates, fewer qualified teachers, broken facilities, fewer academic pathways. A justice raised an eyebrow. Crockett didn't slow. Third, she said, the court's role is narrow. You don't design school systems. You don't set tax policy. You enforce the constitutional floor you already created. She paused, letting the point settle. This isn't about judges becoming school board members. It's about judges refusing to look away when constitutional guarantees are being quietly erased. Crockett then flipped the pressure back onto the bench. The truth is, she said, her voice steady but firm, this court already built the guardrails. You wrote the standards. You defined equal protection. You established that education is essential to democratic participation. She leaned slightly forward. I'm not asking you to invent new power. I'm asking you to stop pretending you don't already have it. The air in the courtroom tightened. Even Justice Kagan paused before responding. Crockett finished with a line that landed like a challenge. If enforcing constitutional rights feels uncomfortable, that's not a flaw in the framework. That's the cost of doing your job. The room went completely still again. The silence that followed wasn't relief. It was pressure. A conservative justice cut in sharply, his tone colder and more direct. Counselor, he said, your argument risks turning this court into a national school board. Education has always belonged to the states. Are you asking us to override local authority? The question landed hard. On the bench, the divide became visible. Several liberal justices leaned forward, elbows near the desk, eyes fixed on Crockett. On the other side, a few conservative justices folded their arms and leaned back, watching with guarded skepticism. Crockett didn't soften her posture. With respect, she replied, state control does not mean state immunity. A ripple moved through the gallery. Federalism was never designed to protect neglect, she continued. It was designed to balance power, not to excuse harm. Her voice sharpened. If autonomy becomes a shield for inequality, then autonomy has crossed the line into abuse of authority. The tension in the room rose another notch. She stepped closer to the microphone, lowering her voice slightly, forcing everyone to listen harder. No one here is asking this court to manage classrooms, she said. What we are asking is simpler and harder. When states create education systems that systematically fail entire communities, this court cannot pretend that's just local preference. A clerk in the second row looked up from his notes, eyes wide. Crockett pressed on. You don't get to wave the word federalism like a magic wand and make constitutional violations disappear. Her tone was calm, but the message was blunt. If children are being denied the basic tools to function as citizens, that is not policy disagreement. That is constitutional abandonment. A few murmurs spread through the press section before being cut off by silence. She paused, letting the words sink in, then delivered the line that shifted the room. Extreme inequality is not an accident, Crockett said. It's the result of decisions, repeated, documented decisions, to tolerate broken schools, underfunded districts, and communities written off as collateral damage. She lifted her gaze to the bench. And when this court chooses not to act, that silence becomes part of the system. The air felt heavy now, charged. Crockett straightened and finished with controlled intensity. This is not about taking power from the states. It's about stopping states from taking futures from children. The courtroom tightened, because the argument had crossed its most dangerous line, from legal theory into moral accountability. Crockett paused, then reached to her side and signaled for the court display to activate. The screen behind the bench lit up, cutting through the marble room like a spotlight. We've talked about theory, she said calmly. Now let's talk about reality. A timeline appeared, stretching across the screen. On the left were districts with stable tax bases and consistent funding growth. On the right were communities where education budgets had barely moved in decades. A low murmur rippled through the gallery before dying out. Crockett didn't wait for permission. "This isn't speculation," she said. "This is documented pattern." She pointed to the screen. In some districts, students receive less than half the per-pupil funding of neighboring communities just miles away. Half. A journalist froze mid-keystroke. Another slowly lowered his laptop screen, staring at the numbers. She stepped closer to the podium, voice tightening. "Now let's connect this to what this court already knows." The next slide flashed. Brown versus Board of Education. Crockett looked up at the bench. This court said inequality in education creates inequality in opportunity. That wasn't poetry. That was a constitutional warning. She tapped the screen again. Graduation rates dropped sharply in underfunded districts. Teacher turnover spiked. Class sizes ballooned. "These aren't abstract statistics," she said. "These are classrooms with broken heating systems, schools without science labs, libraries with outdated textbooks." Her tone sharpened. "And we're still pretending this is just a policy disagreement?" Several justices leaned forward. One clerk stopped writing entirely and stared at the screen. Crockett pressed harder. "Longitudinal studies show that students from severely underfunded districts are significantly less likely to complete college, less likely to earn stable income, and more likely to remain trapped in the same economic conditions they were born into." She let that sit for a second. That is not coincidence. That is design by neglect. A tight silence filled the room. Even the faint sounds of shuffling papers disappeared. Then Crockett delivered the line that shifted the atmosphere. "If this court accepts that equal protection means anything beyond symbolic language," she said, "then it cannot ignore evidence this clear." She gestured toward the screen one last time. "You can argue philosophy. You can debate theory. But you cannot debate these numbers." The courtroom felt different now. It wasn't a place of abstract legal sparring anymore. It was a room facing proof. And as Crockett turned back toward the bench, the message was unmistakable. This case had just moved from argument to accountability. Chief Justice Roberts finally leaned forward, and the movement alone changed the temperature of the room. Everyone knew what this meant. When Roberts spoke, the argument stopped being academic and started becoming institutional. He adjusted his glasses, paused for a long second, and then delivered the question slowly, deliberately. "Representative Crockett," he said, "your argument asks this court to make judgments about educational adequacy. Doesn't that pull the judiciary into policy decisions that belong to legislatures?" The room locked up. This was the line no advocate wanted to cross. Too far, and you look reckless. Too soft, and you look weak. Crockett didn't answer right away. She let the silence stretch, not out of hesitation, but control, forcing every eye in the room to stay on her. When she finally spoke, her voice was steady but carried new weight. "Mr. Chief Justice," she said, "judicial restraint does not mean judicial retreat." A few heads lifted instantly. She kept going. "This court has never been passive when constitutional rights are threatened. It has drawn lines. It has enforced floors. It has stepped in when other branches failed to protect basic guarantees." She glanced briefly toward the bench, then back to the center. "What I am proposing does not ask this court to write budgets, manage districts, or design policy. It asks this court to do what it has always done: determine when government action crosses the line into constitutional harm." The tension tightened. A clerk's pen hovered midair. No one moved. Then Crockett shifted from legal language to something sharper. "If restraint means allowing children to sit in collapsing classrooms while this court looks the other way, that is not neutrality," she said. "That is participation through silence." The words hit hard. She leaned slightly toward the microphone. "The Constitution does not tell this court to protect rights only when enforcement is comfortable. It tells this court to protect rights when they are threatened." Robert's expression remained controlled, unreadable, but the room could feel the collision happening in real time. This wasn't just a question anymore. It was a direct test of the court's self-image. Crockett delivered her final blow with calm precision. "You have already defined the constitutional floor," she said. "You have already said education is essential to citizenship and democratic participation. Enforcing that floor is not activism, it is obligation." She paused, letting the words settle into the marble walls. "The real overreach," she added quietly, "is allowing extreme inequality to continue while pretending the Constitution has nothing to say about it." The courtroom didn't breathe. The silence after Crockett finished her answer did not fade. It expanded. 1 second passed, then another. No justice spoke, no gavel moved. Even the faint rustle of paper stopped. Crockett remained standing, hands still on the podium, eyes forward, waiting. Across the room, attorneys shifted uneasily in their seats. A reporter slowly lowered her phone, unsure whether the moment had ended or was about to explode into something else. And then Chief Justice Roberts leaned forward again. This time, not to question, to interrupt. "Before we proceed," Roberts said, his voice calm but unusually personal, "I want to acknowledge what just happened." A visible shock rippled through the chamber. Several attorneys looked up sharply. One clerk froze mid-sentence while whispering to a colleague. Everyone in that room understood how rare this was. Chief Justices do not pause oral arguments to offer praise. They simply don't. The courtroom felt like it had slipped outside normal procedure. Roberts continued, measured and deliberate. "In my years on this court, I have rarely encountered advocacy that so clearly connects constitutional principle, precedent, and real-world impact." Crockett didn't move. Her expression stayed composed, but the shift in power was unmistakable. Across the bench, Justice Sotomayor tilted her head slightly and nodded once, slow and deliberate. It was subtle, but powerful. Two justices from opposite ends of the ideological spectrum, aligned in public recognition. Roberts went on. "What you presented today reflects a level of preparation and intellectual honesty that strengthens this institution." The words hung heavy in the air. A defense attorney in the gallery exhaled quietly, shaking his head. Another lawyer whispered, "This never happens." The room felt frozen, like everyone was afraid that breathing too loudly might break the moment. Then Roberts delivered the line that shifted everything. "Advocacy of this caliber does not just advance one side of a case," he said. "It elevates the work of this court itself." The impact was immediate. This wasn't personal praise anymore. It was institutional validation. Crockett wasn't just being recognized as a strong advocate. She was being positioned as someone who had raised the standard of the room. The emotional gravity hit hard. Even seasoned attorneys who had argued dozens of Supreme Court cases sat still, absorbing what they were witnessing. The moment Roberts finished speaking, the courtroom didn't relax. It shifted. The energy changed direction, like a current reversing under the surface. Questioning resumed, but the tone was no longer routine. Justices from both sides of the bench leaned forward, no longer circling the edges of the argument. They went straight into the framework Crockett had built, testing its structure, probing its limits, pulling at its strongest points. And Crockett met every question with the same controlled precision. No defensiveness, no victory laps. Just steady, disciplined answers that reinforced the logic she had already laid down. Along the side benches, clerks began copying phrases directly from her argument into their notes. One clerk quietly mouthed her words as she spoke, trying to capture the exact phrasing. In the press row, the quiet buzz returned, reporters whispering to one another, tapping shoulders, passing phones back and forth with quick messages already being drafted. This was no longer just coverage of a case. It was coverage of a moment. Across the courtroom, other advocates waiting for their turn looked visibly unsettled. A senior attorney adjusted his tie 3 times in less than a minute. Another stared down at his notes, flipping pages with growing urgency. They knew what had just happened. The standard had moved. The bar had been raised in public, in front of the entire court. Crockett's calm presence only made the contrast sharper. While others shifted and fidgeted, She remained centered, answering question after question without rushing, without softening her position, without losing control of the narrative. Then came the quiet turning point. A justice who had openly challenged her earlier reframed his next question using her own terminology. He didn't attack the framework anymore. He accepted it as the starting point and tried to work within it. Another conservative justice followed the same pattern moments later. The shift was subtle, but undeniable. Even those who disagreed with her conclusions were now arguing on her terrain. That was the real aftershock. Crockett didn't need applause. She didn't need another interruption. The fact that the court was now operating inside the structure she built was the clearest sign of victory. Within hours, the clip exploded. Law students shared it across group chats. Professors posted timestamps with captions like, "This is how real advocacy is done." Headlines didn't focus on the case outcome anymore. They focused on the moment. Rare bipartisan respect inside the Supreme Court. Cable panels replayed Roberts' words on loop, freezing the frame where he leaned forward and interrupted procedure. Firms began sending internal emails, tagging junior associates and partners alike. "Watch this," one message read. "This is the standard now." By the end of the week, the story had shifted. It was no longer just about education funding. It was about a lawyer who changed the temperature of the highest court in the country. Behind closed doors, Crockett's framework kept resurfacing. Clerks referenced her three-part test in draft memos. Justices who disagreed on ideology still argued using her structure. The debate wasn't about whether her logic existed. It was about how far it should go. That was the quiet victory. Even opposition had to move within the architecture she built. Without leaks, without headlines, her reasoning began shaping the internal conversation itself. When decision day arrived, media countdowns filled screens. Analysts scanned every paragraph. Then it appeared, a rare acknowledgement inside the opinion. Roberts referenced the framework presented during oral argument, crediting it with clarifying the constitutional questions before the court. Phones buzzed instantly. Law school forums lit up. This wasn't symbolic praise anymore. It was permanent. Her argument was now embedded in the court's official record. Weeks later, Crockett stood before students and said simply, "Preparation beats performance. Discipline beats noise." Roberts echoed the same idea in a written statement about the value of rigorous advocacy. Outside the courthouse, politics kept shouting. Inside, something quieter had happened. The empty bench after the storm became the final image. Proof that authority doesn't come from volume. It comes from precision, restraint, and courage. If this courtroom showdown changed the way you see power, justice, and real leadership, don't let the story end here. Hit subscribe now so you never miss the next high-stakes confrontation, the next shocking moment, and the next truth that deserves to be heard. Turn on notifications, drop your thoughts in the comments, and stay with us, because the next battle is already coming.